Hello, and welcome to another episode of Divorce After 50. I'm your host, Shari Frazier. Before we begin, I want to make something very clear. I'm not an attorney. Everything I share here is strictly for informational purposes based on available public resources. If you're facing divorce or thinking about it, please talk with a qualified divorce attorney in your area who can give you advice based on your specific situation. Today, we're talking about how property is divided during a divorce in Kentucky. For those of us divorcing later in life, this can be especially important because we may have accumulated more assets like real estate, retirement accounts, businesses, and dividing those fairly can be a big impact on our future. Let's start with some basics because property division laws vary depending on what state you live in. In the U.S., states generally follow one of two systems: community property or equitable distribution. In community property states, everything earned or acquired during the marriage is considered jointly owned, no matter who earned it or whose name is on the title. In a divorce, marital assets and debts are usually split 50-50. This system is used in places like California, Texas, and a few others. Kentucky, on the other hand, is an equitable distribution state. That means marital property is divided in a way that's fair but not always equal. The court takes several factors into account to decide what that fair split looks like. So, community property is about equality, while equitable distribution is about fairness. Now that we've cleared that up, let's talk specifically about Kentucky. Kentucky's equitable distribution law means the court divides property based on what it considers fair, not necessarily a 50-50 split. That might sound similar, but it gives the court more flexibility. Here's where people sometimes get confused. Just because a state doesn't follow community property rules doesn't mean you're automatically getting half. In fact, in Kentucky, you might get 50%, but you might get more or less. The court looks at how long you were married, what each of you contributed financially and otherwise, your economic circumstances after divorce, and more. In other words, equitable means what's fair, not what's even. Before anything is divided, the court has to sort out which assets are marital property and which are separate property. Marital property includes most assets and debts acquired during the marriage. This is what the court divides. Separate property includes anything you owned before the marriage or received individually as a gift or inheritance. Those usually stay with the original owner. Be careful, though. If you mix separate property with marital property, it can become commingled and possibly be treated as marital in court. Mixing inherited money with joint accounts can make it challenging to prove it's non-marital. Maintain clear records. Documentation can help establish the non-marital nature of an asset. The burden of proof lies with the spouse claiming an asset is non-marital. Kentucky judges look at several factors when deciding how to divide marital property fairly: the length of the marriage, each spouse's contributions, financial or otherwise, the value of assets already assigned to each spouse, and economic circumstances of each party, and number 5, custodial arrangements, especially if children are involved. Debt is treated just like property. It gets divided based on fairness. So if one spouse racked up credit card debt for personal use, the court might assign more of that debt to them. And don't forget, couples can reach their own agreement outside of court through a separation agreement. If both parties agree and the court finds it reasonable, it can become part of the final divorce decree. This route can save time, money, and stress. So in other words, if you and your spouse can agree between the two of you, you won't have to have the court make the final decision, and it will save you a lot. Understanding how Kentucky handles property division can make a big difference, especially when you're divorcing after 50. At this stage in life, the financial impact is real, and you deserve to walk away with what's fair based on your individual journey. As always, I want to remind you that I'm not a lawyer. I'm just here to provide helpful information and perspective. For anything legal, please talk with a qualified divorce attorney. I have other resources that might be able to help you, such as you're giving you financial help, financial planning, insurance professionals. There's just a lot of resources that you can tap into. I'm a real estate agent. I can help you determine the value of your home, the marital home, or other property, or you may want to, get an appraisal done. That might be helpful as well. But there's lots of other professionals who can come along and help you make decisions based on your personal goals and personal situation. So thank you, as always, for joining me on Divorce After 50. I'll talk to you next time. And until then, take care of yourself. And remember, knowledge is power.